Good morning, everyone.
Yeah.
Good morning, Your Honor.
Court is in receipt of a proposed consent judgment of divorce, which can be entered today if Ms. Nemec, the parties both agree to that the court waive the statutory 6-month waiting period. And the parties are separated. I don't know how long they've been separated, but perhaps we can address that in our testimony. Mr. Frank, are you still there? Mr. Frank, what I was explaining is the court can enter the judgment of divorce today that you've approved, provided that you and Ms. Frank agree that we waive the statutory 6-month waiting period and enter the judgment today rather than in August. Under Michigan law, because there's children, there's a 6-month waiting period from the date the divorce complaint was filed. This divorce complaint was filed on February 20th. So 6 months expires August 20th, but this court has the authority to waive that and enter the judgment of divorce today. And the court would do so if you both agree and you believe it would be in the best interest for children to finalize things sooner than later. Okay, that's what the court was trying to explain. Were you able to catch that, Mr. Frank?
Yeah, I caught that.
All right, Mr. and Mrs. Frank, can you both please raise your right hand and be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do. Yeah.
Mr. Frank?
I do.
Okay, thank you. All right, Ms. Nemec, you can begin with Ms. Frank, please.
Okay, and you are the plaintiff in this action for divorce, correct?
Correct.
You and Mr. Frank were married December 19th, 2015 in Monroe County, correct?
Correct.
And you have 2 children.
Correct.
Are you currently pregnant?
No.
And are you stating to this court that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood of reconciliation?
Correct. Yes.
How long have you and Mr. been living separately?
In September of last year.
Okay, and is there any chance that the 2 of you would reconcile or get back together?
No.
So you signed yesterday a consent judgment of divorce, correct?
Correct.
Okay, and you had time to review that?
Yes.
You understood every part of it?
Yes.
Okay, did you have time to think about it?
Yes.
Did you have time to discuss it with me?
Yes.
Is anyone forcing you or coercing you to enter into the agreement?
No.
Okay. Do you think that the provisions in the agreement regarding custody and parenting time of are in their best interest?
Yes.
Okay. Do you believe that the property division in the judgment of divorce that you signed yesterday is fair and equitable?
Yes.
You understand that signing it and submitting it to the court yesterday made it binding on you, right?
Correct.
So you can't come back and ask the court to change any of the provisions in that document regarding the division of property.
Correct.
So for example, there's a spousal support awarded in that judgment of divorce. You can't come and ask the court for more.
Correct.
Because it was non-modifiable, right?
Correct.
Okay. You understand that you could have taken this case to trial and the outcome could have been different. It could have been better or worse, correct?
Correct.
But rather than do that, you're asking the judge to take the judgment of divorce that you signed yesterday and also sign it, therefore making it an order of the court.
Correct.
Have you disclosed all of your assets to Mr. Frank?
Yes.
Okay, and are you satisfied with my representation?
Yes.
Okay. And my last question for you, as you heard the judge indicate, there is a 6-month statutory waiting period that I believe the judge said would be up in August, and it's obviously not August. Do you wish for the court to waive the balance of that waiting period?
Yes.
And is the reason that you want the court to waive the balance of that waiting period because you think it's in their best interest to have some finality and all 4 of you have the ability to move forward?
Yes.
Okay. I have nothing further, but Your Honor, it does look like we lost Mr. Frank. Oh, he's back again.
Right, Mr. Frank, were you able to hear your wife's testimony this morning?
I heard everything, but when it came to the August waiting period, and I heard everything before that.
She indicates she is asking the court to waive that. She believes it to be in the best interest of everyone including you and the children, to waive the waiting period and enter the judgment of divorce now so you can move forward.
And on why it's in the best interest. I understand this is ultimately our chosen path and this is where we're going, but I would like just a brief explanation of why it's in the best interest to dissolve it today or August and what the difference is.
Because we've been separated for so long and we're ready to move forward.
And also, Ms. Frank, do you believe that there is any benefit in delay, considering you've indicated on this record that there's no chance of reconciliation?
Correct.
Mr. Frank, we're going to give you a phone number. You're breaking up, and we cannot record this. So get a piece of paper and a pen and call in, Mr. Frank. We're not going to continue this and breaking up. We need to record these proceedings, and we can't record these proceedings when you're breaking up. So please phone us.
5 minutes later.
Hello.
Yes, we're back on the record in the matter of Leah Frank versus Anthony Frank. Mr. Frank, are you currently present on audio?
Yes.
Good, much better. Okay, so we were left off, you indicate you did not hear your wife's testimony regarding the 6-month waiting period. She testified that you've been separated since last fall, and there's no chance of reconciliation. She believes it to be in the best interest of all parties, herself, you, and the children, to waive the balance waiting period and enter the judgment of divorce today rather than waiting till August. That was her testimony.
Correct.
Right, so sir, can you please state your name and current address for the record?
Yes, Anthony Frank.
Thank you. Mr. Frank, did you hear the testimony this morning of your wife, Leah?
I did.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Did you, in fact, sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
Do you understand that even though Ms. Nemec is helping facilitate resolution of this matter, she represents your wife, Leah, and her loyalties lie with Leah? Do you understand that?
I do.
Did you approve this judgment freely and voluntarily?
I did.
The last question, Mr. Frank, are you asking the court to waive the balance of a 6-month waiting period and enter the judgment of divorce today? Or do you want to delay this till August?
I think August is beneficial, actually, for a couple reasons. I mean, we're still going to remain the same relationship. We're still going to be living separately. But, I think that both of us need to, for the children's sake,
I will have to pay the
Stop. Let him speak.
Do you want to talk in a breakout room, Ms. Nemec, with the parties?
I can.
If that's what happens, you have to enter some temporary orders regarding child support and some other issues.
Yeah, I understand, Your Honor. I will attempt to resolve this issue, but I think it's pretty clear that Ms. Frank's position is that the judgment of divorce should enter today. I don't understand why Mr. Frank disagrees if he signed both the orders and the judgment of divorce, and it seems like this is only an attempt to delay proceedings, but I will attempt.
The court would note that the two of you, which is the court applauds you for being able to co-parent your children. You've agreed to joint legal, joint physical.
Right.
And Mr. Frank, the reality is, unless you think there's a prospect of reconciliation, there appears to be no sense in delaying this. I mean, for the benefit of the children, unless you think that Mrs. Frank's can change her mind and wants to reestablish the marriage relationship, you want to move back in together.
No, I don't see that happen in 6 months. I mean, she ultimately yesterday said that she would love to see that down the road, but I don't know how true that is or not. My sole purpose is saying that I think we need time to not, to focus on the children here and not just say, okay, I'm free, let's start my new life here. Both of us need that time to really be mature and focus on that. And so that little buffer, just a couple more months, would say, okay, listen, yeah, I mean, this is pretty much final, but we're still technically married. I mean, that
makes no sense.
Yeah,
You know,
well, is that my right?
Not these children. You're always going to be parents of these children. You need to be friends. You need to get along. And obviously, you started on the right direction. You've agreed to co-parent children, which is wonderful. You've agreed to parenting time. You're in the minority where the two of you can work together for the best interest of your children. and you need to be on the same page for the benefit all the future years. You always need to make sure, Mr. Frank, your mom, the kids get a card from mom for Mother's Day, and likewise, mom gets a card for the children for Father's Day. None of that's going to change. It's just a matter of if you think there's a chance of reconciliation. Otherwise, we need to enter some temporary orders regarding child support. I'm sure she needs assistance. If you're separated, we need to address some of these matters, such as not only child support. You've addressed, spousal support. We need an order entered for spousal support. You're going to start paying spousal support on July 1st. So we need temporary orders and the real estate. Who's gonna pay the house payments between now
I pay all of that
in August?
Well, it's still in my name. So whether I sign this judgment or not, I'm bound to that until she refinances.
No, you're not bound by it until the court signs an order. You're not bound by anything, Mr. Frank.
Well, not bound, but that's my credit and my reputation there.
Okay, so are you who's going to make the payments then? We need to address all these issues. We need a temporary order. If you are refusing to allow authorized court to sign judgment of divorce today, well, first of all, convince the court that it's not in the children's best interest. You may not like it, may not be in your best interest, but what about the children? That's what the court's focusing. So convince this court this morning that it's in the best interest of children to delay this matter.
Depending
Yeah.
on my situation.
Yeah.
I don't know who's talking here.
All right, Ms. Nimick, do you want to talk with the parties or you just want to maybe court chair for Mr. Frank?
I'm fine, Your Honor. If you'd like to hear Mr. Frank, I obviously will have a response to whatever he has to say.
All right, so Mr. Frank, just tell the court, in your opinion, why it's in the best interest of children to delay things, to delay the inevitable. Normally, there's always some value and finality to all people, all human beings, including children.
There's a what in the finality? I'm sorry, Judge.
There's value to finality, so people know where they're going.
A 3-year-old and 5-year-old.
Children to expect that mom and dad are going to get back together. That's cruel if in fact you think that you're going to try to convince the children that mom and dad are going to get back together.
Yeah, of course, our 3- and 5-year-old hope and wish for that, and we don't plan to have that discussion with them anytime soon. We plan to just love them as we have been. But my sole position on whether it happens today or August would be just like a cool off period where, as far as the children's interest, that neither one of us say, okay, I'm free from this divorce. I'm going to go off and, do what I want now. And the freedom aspect overtake the position of this has to be about our children from this point. So it's just basically a buffer to have a cool off period and say, okay, we have a few months here, and
the court's not going to allow you, Mr. Frank, to decide that cooling off buffer period. The reality is, if it's the best interest of children to finalize things. So I'm going to have you talk with Ms. Frank. If in fact you think there's a prospect of reconciling, then that's one thing. But that's only a basis to delay this. If you think there's a chance of reconciling, so I'm going to have you talk with Ms. Frank. Maybe she's changed her mind. So we're going to put you in a break room. You can talk with Ms. Frank. And if in fact she agrees that there's a chance of reconciliation, then perhaps the court will delay this. Otherwise, it appears that the court should end the judgment of 2 days. So we're not holding out false expectations for the children.
Right. That's been my heart from the beginning is reconciliation.
Okay. You need to hear from Ms. Frank. So Ms. Frank, we're going to put you in a breakout room. You can talk to your husband and let him know whether or not there's a chance of reconciliation.
11 minutes later.
Or we call the case of Leah Frank versus Anthony Frank. And Mr. Frank, are you present on audio again?
Yeah.
All right. Ms. Nemick, Mr. Frank, you've had a chance to talk with your wife. Do you believe there's a chance of reconciliation in the next couple months?
Not at this point in the next couple months, but down the road, who knows with things. I do know that yesterday there was a huge push in the 11th hour to get me to sign papers that I didn't really even get to look over the revision. I mean, I looked them over.
Hold
there were
on,
a few
stop right
revisions.
there. Stop right there, Mr. Frank. I thought you said you reviewed everything and you understood
I
everything.
did,
You signed
I
up
did.
freely and voluntarily. Are you now saying that you did not sign it voluntarily?
No, I did. I'm just telling you that why I have a reasonable level of discomfort is yesterday they messaged me with the revision of this and said you have a half hour to sign it, and I looked it over. I did, and I still
We had
signed
a
it.
court date. Mr. Frank, we had a court date today. Ms. Nimick is trying to be efficient. We had a court date today.
Right,
That is
I understand.
correct, Your Honor. And what actually happened is I changed one sentence in the judgment of divorce that Mr. Frank has had since last week sometime, I believe. And that sentence was changed at his request. We redefined 1 week of vacation from 7 days to 5 days. There was one sentence change. I did advise that it needed to be signed within a half an hour in order for me to get it to the court in time for the court to have access to it before this morning.
All right, so Mr. Frank, are you asking for an adjournment so you can consult on the retaining attorney? Is that correct?
I personally would like that, but I know that Leah is just ready to be done with this.
All right. The court, how much time do you need to hire an attorney? Can you do that in 2 weeks?
Well,
Anthony.
listen, let me finish the sentence. I don't think an adjournment's going to change a whole lot. I just have to say that Leah's, it's not even about the relationship or salvaging it, but Leah's.
Mr. Frank, do you want to talk to an attorney? I've got the other parties waiting. Again, I understand you want to talk. And again, the reality is, if in fact you don't want the court to enter this judgment today, do you want to talk to an attorney? The court will adjourn this, give you a chance to talk to an attorney.
Yes or no?
Mr. Frank?
I'm sorry. Yeah, I heard her talking too. I'm sorry. Yeah.
All right, court's going to adjourn this matter. Mr. Frank,
No,
contact an
I don't
attorney
think-
forthwith. We're not going to play games, Mr. Frank. The court is
I'm
a
not.
busy docket.
I'm actually.
Ms. Nimick is busy, so we're going to give you another date in about
Anthony,
would
Michael.
2 or 3 weeks be
Yeah,
sufficient?
I'm listening. Listen, let's get it done. I'm telling you, I'm not comfortable with this, but I don't think it's going to change much.
Mr. Frank, stop right there. We're not going to proceed any further this morning. You're saying you're not comfortable with this? Of course, not proceed with
No,
a
Judge,
entry of judgment. You're not comfortable with it. So stop talking, Mr. Frank. We'll give you a date. Ms. Nimick, what day in July are you available on a Friday?
Ms.
Your
Nimick, can we
Honor.
please?
Miss Cindy?
Your Honor.
Hold on.
May I? Yeah.
No, Mr. Frank, I got other matters waiting. There's, we don't have time to talk. You can talk with an attorney about these matters.
No, there's no attorney. Let's just get it over with.
Ms. Nimick, hold on. Mr. Frank, do not interrupt, please. We're looking at some dates in July.
The earliest
I don't want to.
available in July, Your Honor, it's July 19th.
Your
Ms.
Honor,
Nimick.
I don't want to do this to her. I don't want to do this.
Do anything about what he's saying on the record, Leah, okay?
I don't want to do this to her. I want to finalize it.
July
I'll just
19th
do
at
it.
9 o'clock. Ms. Nimick, you available July 19th at 9 a.m.?
I am, Your Honor.
All right, this matter is adjourned to July 19th, 9 a.m. Mr. Frank, please consult an attorney so we can move forward with this matter. Talk to an attorney and find
Your
out what
Honor.
your options are. We'll mail you notice
Your
at
Honor.
the Huron River Drive address, and this matter is concluded. We're adjourned. Have a good rest of the day. You can zoom out.
Your Honor.